everyone. Today let's start with the topic labor welfare legislation. So let's see what is the term labor legislation. The term labor legislation is used to cover all the laws which have been enacted to deal with employment and non-employment wages, working conditions, industrial relations, social security and welfare of person employed in industries. Okay, so now let's see the need for labor legislation in India. Here it is being said that organized industry in a planned economy calls for the spirit of cooperation and mutual dependence for attaining the common purpose of greater, better and cheaper production. Since this has not been happening voluntarily, it created the need for state intervention in India. Labor legislation is treated as an arm of the state for the regulation of working and living conditions of workers. The need for labor legislation is summarized as number 1 is necessary for the health, safety and welfare of workers. Number 2 is necessary to protect workers against oppressive terms as the individual worker is economically weak and has little bargaining power. To encourage and facilitate the workers in the organization. To deal with industrial disputes. To enforce social insurance and labor welfare schemes. And the objectives of labor legislation are twofold: preservation of health, safety and welfare of workers, and number 2 is maintenance of good relations between employers and employees. Okay. Now let's see the principles of labor legislation. Number 1 is social justice. The essence of democracy is ensuring social justice to all the sections of the community. This demands the protection of those who cannot protect themselves. যোনবিলাক workers or নিজকে protection মানে দিয়াৰ বা protect কৰাৰ যোনটো ability টো নাই হিহঁতৰ কাৰণে social justice ৰ কাৰণে এইবিলাক principles বনোৱা যায় and labor welfare legislation হে কাৰণে বনোৱা গৈছে যাতে we can protect them. In modern industrial setup, workers who are left to themselves are unable to protect their interests. Therefore, the state has to intervene to help them by granting them freedom of association, the power of collective bargaining and by providing mediation or arbitration in the case of industrial conflict. Okay. Number 2 is social equity. Legislation based on this principle provides for achievement of definite standards in terms of living, position in society of the working population. These standards for the working class can be achieved by bringing about changes in the law of our land. Number 2 is power to change the law is exercised by the government. Existing laws may be amended to meet the changed standards. Number 3 is national economy. Measures have to be provided through legislation to ensure normal growth of the industry for the benefit of the nation as a whole, satisfy the physical and intellectual needs of the citizens. Number 2 is ensure the growth of industrial efficiency such as to adjust the wage system with a view to increase the productivity and prosperity of the workers. Number 4 is international uniformity. Since its inception, securing minimum standards for the working population worldwide on a uniform basis in respect of all labor matters has been the main objective of ILO. To this end, conventions are passed in the conferences of ILO. As a member of ILO, adopting these conventions would require appropriate legislation to be brought in. The influence of international labor conventions has been significant in shaping the course of labor legislation in India. So let's see the labor legislation in India. Labor laws may be classified under the following heads. Number 1, laws related to industrial relations, that is Trade Union Act 1926, Industrial Employment Standing Order Act, that is established in 1946, Industrial Disputes Act 1947. Number 2 is laws related to wages, Payment of Wages Act 1936, Minimum Wages Act 1948, Payment of Bonus Act 1965, Working Journalist Fixation of Rates and Wages Act 1958. Number 3 is laws related to working hours, conditions of service and employment. In this category falls the Factories Act 1948, Plantation Labor Act 1951, Mines Act 1952, Working Journalist and Other Newspaper Employees Conditions of Service and Miscellaneous Provisions Act 1955, Merchant Shipping Act 1958, Motor Transport Workers Act 1961, etc. Laws related to equality and empowerment of women such as Maternity Benefit Act 1961, Equal Remuneration Act 1976, laws related to deprived and disadvantaged sections of the society such as Bonded Labour System Abolition Act 1976, Child Labour Prohibition and Regulation Act 1986, Children Pledging of Labour Act 1933, laws related to social security such as Workmen's Compensation Act 1923, Employees State Insurance Act 1948, Employees Provident Fund and Miscellaneous Provisions Act 1952, Payment of Gratuity Act 1972, etc. Now let us look upon the Factories Act 1948. The Factories Act is a social legislation which has been enacted for occupational safety, health and welfare of workers at workplaces. This legislation is being enforced by technical officers, that is Inspector of Factories, Deputy Chief Inspector of Factories, who work under the control of the Chief Inspector of Factories and overall control of Labour Commissioner, Government of National Capital Territory of Delhi. Application of this act. Applicable to the whole of India including Jammu and Kashmir. Number 2, covers all manufacturing processes and establishment falling within the definition of factory. Number 3 is applicable to all factories using power and employing 10 or more workers, and if not using power, employing 20 or more workers on any day of the preceding 12 months. Objective of this act: to ensure adequate safety measures and to promote the health and welfare of the workers employed in factories, to prevent haphazard growth of factories through the provisions related to the approval of plans before the creation of a factory. Scheme of the act: the act consists of 120 sections and 3 schedules. Schedule 1 contains a list of industries involving hazardous processes. Schedule 2 is about permissible level of certain chemical substances in work environment. Schedule 3 consists of list of notifiable diseases. Important provisions of the act: facilities and conveniences. The factory should be kept clean. There should be an arrangement for disposal of waste and effluents. Ventilation should be adequate. Reasonable temperature for comfort of employees should be maintained. Dust and fumes should be controlled below permissible limits. Artificial humidification should be at prescribed standard level. Overcrowding should be avoided. Adequate lighting, drinking water, washroom and spittoons should be provided. Okay, so in the welfare category, adequate facilities should be provided for washing, sitting, storing clothes when not worn during the working hours. Adequate first aid boxes should be provided. Facilities in case of large factories: first aid room if 500 or more workers are employed. Canteen if 250 or more workers are employed. It should be sufficiently lighted, ventilated and suitably located. Restrooms, shelters with drinking water when 150 or more workmen are employed. Creches if 30 or more women workers are employed. Full-time welfare officer if factory employs 500 or more workers. Safety officer if 1000 or more workmen are employed. Okay, regarding safety, all machinery should be properly fenced to protect workers when it is in motion. Pressure plants should be checked as per rules. Safety appliances for ice, dangerous dust, gas and fumes should be provided. In case of hazardous substances, additional safety measures should be prescribed. Safety officer should be appointed if number of workers in factory are 1000 or more. Working hours: a worker cannot be employed for more than 48 hours in a week. Weekly holiday is compulsory. If he is asked to work on weekly holiday, he should have full holiday on one of the 3 days immediately or after the normal day of holiday. He cannot be employed for more than 9 hours in a day. At least half an hour rest should be provided after 5 hours. Total period of work inclusive of rest interval cannot be more than 10.5 hours. A worker should be given a weekly holiday. Overlapping of shifts is not permitted. Notice of period of work should be displayed. Rules and regulations regarding the workers, which should be maintained by the employers in the industries and factories. Number 6 is overtime wages. If a worker works beyond 9 hours a day or 48 hours a week, overtime wages, double the rate of wages, are payable. Okay. An employee working outside the factory premises, like field workers etc. on tour outside headquarters, are not entitled to overtime. Number 2 is a workman cannot work in 2 factories. There is restriction on double employment. Now let's look upon the employment of women. A woman worker cannot be employed beyond the hours 6 am to 7 pm. State government can grant exemption to any factory or group or class of factories, but no woman can be permitted to work during 10 pm to 5 am. Shift change can be only after weekly or other holiday and not in between. So these are the rules that needs to be properly followed by the employers in the industries and factories, otherwise they might lose their license. Okay. Child employment. Children below age of 14 years should not be employed. Children above 14 but below 15 years of age can be employed, but only for 4.5 hours per day. He should be certified fit by a certifying surgeon. He cannot be employed during night between 10 pm to 6 am. A person over 15 but below 18 years of age is termed as adolescent. He can be employed as an adult if he has a certificate of fitness for a full day's work from certifying surgeon. An adolescent is not permitted to work between 7 pm and 6 am. There are more restrictions on employment of female adolescent. Register of child workers should be maintained. Administrative machinery. The enforcement of this legislation is being carried out on district basis by the district inspector of factories. After inspection, improvement notices are issued to the defaulting management and ultimately legal action is taken against them. Penalties. This act provides for a maximum punishment up to 2 years or a fine of up to rupees 1 lakh. Now okay, so now let's look upon the Employees Provident Fund and Miscellaneous Provisions Act 1952. The umbrella legislation relating to a provident fund is the Employees Provident Funds and Miscellaneous Provisions Act 1952. The act come into existence with the main objective of making some provisions for the future of industrial workers after their retirement for their dependents in case of death. Okay, it is applicable to every establishment which is engaged in any one or more of the industries specified in Schedule 1 of the Act, or any activity notified by central government in the official gazette and employing 20 or more persons. However, the Act shall not apply to any establishment registered under the Cooperative Societies Act 1912 or under any other law for the time being in force in any state relating to the cooperative societies employing less than 50% and working without the aid of power. So this is one. Number 2 is belonging to under the control of central government or a state government whose employees are entitled to the benefits of contributory provident fund or old age person in accordance with any scheme or rule framed by central government or state government governing such benefits. Number 3 can be set up under any central provincial or state act whose employees are entitled to the benefits of contributory provident fund or old age person in accordance with any scheme or rule framed under the act governing such benefits. Number 4 is newly set up until the expiry of a period of 3 years from the date on which such establishment has been set up. Okay, now let's look upon the Workmen's Compensation Act 1923. The Workmen's Compensation Act 1923 provides for the payment of compensation to workmen and their dependents in case of injury and accident arising out of and in course of employment and resulting in disablement or death. Okay. The main provisions of the act are: an employer is liable to pay compensation if personal injury is caused to workman by accident arising out of and in course of his employment. If a workman employed in any employment contracts any disease specified in the act as an occupational disease peculiar to that employment. Number 2 is, however, the employer is not liable to pay compensation in the following cases. Ki kesot employer jone compensation dibo laga nohoy. If the injury does not result in the total or partial disablement of the workman for a period exceeding 3 days. If the injury not resulting in death or permanent total disablement is caused by a accident which is directly attributable to the workman having been at the time of the accident under the influence of drink or drugs, or the willful disobedience of the workman to an order expressly given or to a rule expressly framed. Okay. Number 3 is, the state government may by notification in the official gazette appoint any person to be a commissioner for workmen compensation for such area as may be specified in the notification. Number 4 is, compensation shall be paid as soon as it falls due in cases where the employer does not accept the liability for compensation to the extent claimed. He shall be bound to make provisional payment based on the extent of liability which he accepts, and such payment shall be deposited with the commissioner or made to the workman as the case may be. Okay, now let's look upon the Employees State Insurance Act 1948. The Employees State Insurance Act 1948 provides for healthcare and cash benefit payments in case of sickness, maternity and employment injury. The act applies to all non-seasonal factories with power and employing 10 or more person, and to those factories that run without power and employ 20 or more person. The basic provisions of the act are, every factory or establishment to which this act applies shall be registered within such time and in such manner that as may be specified in the regulations made in this behalf. It is provided for an integrated need-based social insurance scheme that would protect the interest of workers in contingencies such as sickness, maternity, temporary or permanent physical disablement, death due to employment injury resulting in loss of wages or earning capacity. It is also provided for 6 social security benefits: medical benefit, sickness benefit, maternity benefit, disablement benefit, dependence benefit, funeral expenses. Let's see the Payment of Wages Act 1936. The Payment of Wages Act 1936 is a central legislation which has been enacted to regulate the payment of wages to workers employed in certain specified industries and to ensure a speedy and effective remedy to them against illegal deductions or unjustified delay caused in paying wages to them. It applies to the persons employed in the factory, industrial or other establishment or in railway, whether directly or indirectly through a subcontractor. Further, the act is applicable to employees drawing wages up to 18,000 per month. Okay. Now there are Apprentices Act as well, established in 1961. Let's look upon that. The Apprentices Act 1961. The Apprentices Act 1961 was enacted to regulate and control the program of training of apprentices and for matters connected therewith. The term apprentice means a person who is undergoing apprenticeship training in pursuance of a contract of apprenticeship, while apprenticeship training means a course of training in any industry or establishment undergone in pursuance of a contract of apprenticeship and under prescribed terms and conditions which may be different for different categories of apprentices. The main provisions of the Act are: Central Apprenticeship Council has been established as an apex statutory tripartite body to advise the government on laying down policies and prescribing norms and standards in respect of apprenticeship training scheme ATS. No person shall be engaged as an apprentice to undergo apprenticeship training in a designated trade unless such a person, if he or she is a minor, his or her guardian has entered into a contract of apprenticeship with the employer. Every trade apprentice undergoing let's see the third one. Every employer shall have the following obligations in relation to the apprentice, namely to provide the apprentice with training in his or her trade in accordance with the provisions of the Act and the rules made thereunder. Number 2 is to provide adequate instructional staff possessing such qualifications as may be prescribed for imparting practical and theoretical training and facilities for trade test of apprentices. Number 4 is every trade apprentice undergoing apprenticeship training shall have the following obligations, namely to learn his or her trade and diligently and endeavor to qualify himself or herself as a skilled craftsman before the expiry of the period of the training. Number 2 is to attend practical and instructional classes regularly, to carry out all lawful orders of his or her employer and superiors in the establishment, to carry out his or her obligations under the contract of apprenticeship. So, these are the following main provisions of the Act of Apprentices Act 1961. Besides that, you need to learn about the laws which I have told, Trade Union Act, Industrial Employment Standing Order Act, Industrial Disputes Act 1947, laws related to the wages, laws related to working hours, laws related to equality and empowerment of women, laws related to social security, and laws related to deprived and disadvantaged section of the society. So you need to learn about this thoroughly. Since it is not being provided in the book, I'll try to finish this after I have finished the next chapter, which is quality tools. So with this we have learned about the acts of the workers, various acts and various laws which must be implemented in the factories and the industries for the welfare of the working class. So with this we come to the end of the chapter. Next we will look upon the quality tools chapter.